The calendar may declare a new year, yet the unresolved tensions of our political and legal order persist, demanding examination in the clear light of present reality. Recent acts of corporate protest, such as a hotel's refusal to serve federal agents, are not merely fleeting headlines. They are acute symptoms of chronic conflicts between conscience and contract, between state and federal authority, and between the limits of civil rights law and the expansiveness of moral protest. These incidents compel us to move beyond polemics and into a rigorous analysis of the fragmented legal landscape that ultimately governs such confrontations. January 5, 2026. Welcome to the Big Dog Daily Podcast. The decision by a Minnesota Hampton Inn to refuse lodging to Federal Immigration and Customs Enforcement (ICE) agents and the subsequent termination of its contract by the General Services Administration (GSA) presents a compelling microcosm of modern political conflict. It sits at a tense juncture where administrative, constitutional, and civil rights frameworks converge across multiple levels of government. A comprehensive legal analysis reveals a calculated act of protest that carefully navigated around the most potent federal civil rights statutes, but potentially collided with state public accommodation laws and unequivocally breached a federal contract. This incident thus serves as a prime study in the strategic calculus of non-state actors and the variable geometry of legal risk and political dissent. A brief word on today's support. This episode is brought to you by Timothy Renier Insurance. As an independent agent now offering auto insurance in Arizona, Timothy leverages his expertise to secure tailored coverage that fits your life and budget. For a quote that saves you both money and time, call 602-341-5290. License number 6734192. Federal law, contractual breach and the limits of Title II. At the federal level, the clearest violation was of contract law, not civil rights law. The GSA's federal travel regulation creates a binding agreement with participating hotels, mandating service to all federal personnel. The hotel's categorical refusal was a direct breach, meriting the administrative sanction of removal from the program, a straightforward defense of a systemic federal resource. The more complex question is whether the act violated federal civil rights law, specifically Title II of the Civil Rights Act of 1964, 42 U.S.C. Section 2000 AACQ, which prohibits discrimination in public accommodations on the grounds of race, color, religion, or national origin. The hotel's policy targeted occupation and employer, not any protected class characteristic of the individual agents. While politically charged, this distinction is legally significant. Federal courts have consistently refused to expand Title II's enumerated categories. Furthermore, a potential claim under 42 U.S.C. Section 1981, which guarantees all persons the right to make and enforce contracts as is enjoyed by white citizens, would likely fail for similar reasons, as the refusal was not based on the race or alienage of the agents. Thus, at the federal statutory level, the hotel operated in a zone of permissible protest, having avoided the core prohibitions of the nation's primary public accommodations law. State and local law, the potential for broader protections. The legal analysis shifts significantly at the state level, where Minnesota law may pose a greater risk to the hotel's policy. Minnesota's Human Rights Act, MHRA, is notably more expansive than its federal counterpart. It prohibits discrimination in public accommodations not only on the basis of federal categories, but also on the basis of creed and national origin, with creed being broadly interpreted to include political or moral belief systems. A compelling argument could be made that refusing service to ICE agents constitutes discrimination based on the agent's perceived political affiliation or creed, their belief in, or association with, the mission of federal immigration enforcement. If interpreted this way by a state court or the Minnesota Department of Human Rights, the hotel's policy could be found unlawful under state statute, exposing it to civil penalties and damages. Local ordinances, particularly in more progressive municipalities, could echo or even broaden these state-level protections. While less likely to apply to a specific incident without a local ordinance directly on point, this underscores the fragmented legal landscape. The hotel's primary legal vulnerability, therefore, likely resides not in Washington, D.C., but in St. Paul, Minnesota. Constitutional considerations. Unlikely defense. The hotel might attempt a constitutional defense under the First Amendment, framing the refusal as compelled speech or association, arguing that being forced to host federal agents violates its owner's expressive freedoms or moral convictions. However, such a defense faces a steep hurdle under prevailing precedent. While the Supreme Court has recognized certain First Amendment exemptions for expressive associations or artistic services, Masterpiece Cake Shop, a standard commercial hotel offering impersonal lodging services is generally not considered an expressive entity. Courts are highly skeptical of claims that routine commercial conduct constitutes protected speech. The state's compelling interest in ensuring equal access to public accommodations would likely outweigh a hotel's claim of ideological objection to a customer's lawful profession. Conclusion: a strategic gamble within a fragmented legal order. In conclusion, the Lakeville incident is a textbook case of strategic political action within a multi-layered legal system. The hotel almost certainly calculated and accepted the federal contractual consequence, loss of a government revenue stream, as a cost of its protest. It relied on the narrow, enumerated categories of federal civil rights law to shield itself from a Title II lawsuit. Its greatest legal peril, however, lay in the more expansive provisions of Minnesota state law, which protects creed and could transform an act of political protest into actionable discrimination. This dynamic highlights a critical feature of American federalism. State governments can and do serve as laboratories of stricter regulation, potentially curtailing forms of dissent that federal law permits. The episode ultimately reveals that the legality of such protests is not a binary national question, but a variable one, dependent on the often overlooked specifics of state statute and the interpretive leanings of local jurisdictions. And if the findings of this bench resonate within you with the force of settled law, if you recognize in this judgment a correct application of principle, then let that recognition be recorded. Let it be entered into the docket by hitting the like button. Furthermore, if you deem such jurisprudential reasoning vital to the defense of our foundational liberties, if you believe this line of precedent must be preserved and its arguments amplified for the common good, then you are hereby ordered to subscribe. Now, for the informed citizenry is not a passive body, it is the final arbiter. In you distinguish a sound ruling from a flawed one, particularly when it is grounded in statute and delivered with authority. This concludes the present session. Court is adjourned. Go forth and uphold the rule of law.